My name is Jerry Martin. I'm a past president for Washington Realtors, and I want to welcome everybody to our second Fair Housing webinar of our four-part series. So today we're going to be discussing the assistance animals, and we're going to be speaking with Marley Hochendoner. Ms. Hochendoner has served as the executive director for Northwest Fair Housing Alliance, which is a nonprofit, it's a private nonprofit fair housing education and advocacy organization that's based out of Spokane, Washington, and had been doing that for the last 15 years, for more than that actually. And prior to joining that organization, Ms. Hochendoner was an in-house staff attorney and a policy analyst for the Nez Perce tribe from 2003 to 2005, and a staff attorney at Idaho Legal Aid Services from 1998 until 2003, where she practiced landlord, tenant, and domestic relations law. Ms. Hochendoner has taught landlord-tenant law as adjunct faculty of Gonzaga University School of Law. Gonzaga, huh? That sounds familiar, doesn't it, recently? Go Gonzaga with the basketball team. And she served also as an adjunct faculty, as I mentioned, to the school there, and as a licensed attorney in Washington, and has an inactive license there in Idaho. She is a Washington State licensed real estate instructor and a member of the Greater Spokane Progress Race Equity Subcommittee and Trainers Cohort. So Marley's going to present, and then we'll have some time for questions if we do. So hold those if you would. Marley, thank you so much for joining with us today. You have the floor and our undivided attention, and thank you so much for being here today.
Thank you so much, Jerry and Liz, for inviting me to talk with some of your membership this morning. It is a lovely, beautiful, sunny day. I'm here in Spokane in my basement, hoping to get out in the near future and start doing more events in person, but really happy to be here. I am going to share my screen here and bring up a PowerPoint. And I'll give it a sec. Okay, hopefully you folks are seeing the title slide. Great, okay. So yeah, we have about an hour here to talk about assistance animals and fair housing and how these apply in your work with working with home buyers and perhaps tenants if you do any property management as well. So this is a topic that gets a lot of attention. There's a lot of confusion, a lot of emotion about it, some frustration, and we'll hopefully demystify some of that this morning. It's the analysis when it comes to assistance animals is actually not that complex. You would think that there are volumes in the fair housing regulations about assistance animals, and animals are not mentioned one time at all. So we'll we'll go through why that is and how you can simplify this analysis if you're encountering an assistance animal situation. So I am, thanks for the introduction, Jerry. I am the director of Northwest Fair Housing Alliance, and we've been around since 1994 here in Spokane and serve 17 counties in eastern and central Washington. I do like Zoom because I get to reach out to even more people beyond those counties sometimes. So if I haven't worked with you before, thanks for attending this session. So when it comes to assistance animals in housing, there are several laws that can apply, and this is part of the confusion, why there is so much misunderstanding about what kinds of animals are allowed, what kind of species breed, what kind of limitations can be put on them. So there's several different laws that we need to consider. We are primarily going to be talking about the Fair Housing Act today because that definitely applies in real estate transactions. There are also some other laws that may come into play as well, depending on the type of property. Americans with Disabilities Act, Section 504 of the Rehabilitation Act, and the Washington Law Against Discrimination are state fair housing law. So the Americans with Disabilities Act, in brief, applies to public and common areas. So this is if you are taking an animal into, for example, a grocery store or the library, a public setting. So the Americans with Disabilities Act is going to apply there. And unlike the Fair Housing Act, the ADA does have regulations that provide a definition of a service animal. And in recent years, the Department of Justice limited that definition to service animals that are trained dogs or miniature horses, and nothing else. So no emotional support animals, no cats, no parrots, no ferrets, trained dogs and miniature horses. Some of you may be wondering about the miniature horse. That is a new one for some people. They can be smaller than some of the large breed dogs, and there is some advocacy for people to use miniature horses as assistance animals because they live about 3 times as long as a dog, so you don't have to train them as often. Apparently they can be housebroken, so this may be something that you start to see more often, but that is specifically permitted in the ADA regulations. So trained dogs, miniature horses, no emotional support animals, no other species. So that's our ADA. I'm not going to talk a lot about that. Hearing a little bit of background there now and then, but yeah, if you haven't muted your sound, please do so. Thank you. Okay, so then we also have Section 504 of the Rehabilitation Act. This applies to housing that receives federal funding. So recipients of federal funding have a heightened obligation to make sure that our federal funds are accessible to as many people as possible. So recipients of federal funding need to provide reasonable accommodations. They need to ensure equal access to people with disabilities, and they need to make sure that they serve people with disabilities in an integrated setting. So if it's a housing complex that receives federal funds, and that's not just receiving a Section 8 voucher, that's more like a federal grant or loan, then there is this additional requirement to provide accommodations. Okay, so, and then I'll get into some of the changes about our state law near the end and explain how that segues as well. So ADA, public areas, federal funding have some additional obligations under Section 504. The Fair Housing Act applies to essentially all housing. There are some limited exemptions for some smaller owners of homes, but they're pretty limited. And our state law narrows those exemptions even further. So it's best to assume that you're covered when you're dealing with real estate transactions. So the Fair Housing Act will apply to private housing as well as to private market housing as well as subsidized federal housing. So Fair Housing Act applies to housing. There's no mention of assistance animals, service animals, comfort animals, anything like that in the regulations. We are simply going to use, if you remember nothing else from today, this reasonable accommodation analysis. 3 points. Is there a disability for the person who's asking to have an animal in housing? Is there a nexus, a relationship between their disability and what they're asking for to have an animal? Is there a connection? And is the request reasonable? And there are some different things that go into that reasonableness factor, but that's the analysis that you want to follow. So starting with disability, disability is one of the 7 protected classes in the Federal Fair Housing Act. It's also protected under our state law. And there are more provisions in the fair housing laws that have to do with disabilities than any other protected class. So our fair housing laws require that people with disabilities be granted reasonable accommodations, which an assistance animal is just one type of reasonable accommodation. Again, you'd think it was its whole subset of something, but it is a reasonable accommodation, which is an exception to a rule or a policy. That's what a reasonable accommodation is, exception to a rule or a policy. Other examples of an accommodation might be asking for a reserved parking space. If a housing community has reserved parking or has first come first served parking, somebody with mobility impairments because of disability may ask for a reserved parking spot. That's an exception to that policy. So assistance animals is a reasonable accommodation. There's also reasonable modifications have to do with structural changes, adding grab bars, ramps, things like that, and then design and construction for new construction. So I'm not going to focus on the last 2. So a reasonable accommodation needs to be granted when a person has a disability, there's a nexus, and it's reasonable. And reasonableness gets into, is there an undue financial or administrative burden? It shouldn't cost a housing provider a lot of money to give an accommodation. They shouldn't have to do a lot of paperwork, have an administrative burden to grant it. And it shouldn't be a fundamental alteration to the business. So if a condo association is not in the business of providing supportive living services, it's probably a fundamental alteration to ask someone from the condo board to come in and administer medications or take someone to the grocery store. That would be an example of a fundamental alteration that's not reasonable for an accommodation. Okay, so if it's reasonable, accommodations should be granted. Not reasonable, then HUD requires that you enter into an interactive dialogue with the person who's asking for the accommodation. So if you can think of an alternative, it's okay to suggest that. If you need more information, it's okay to try and open the dialogue a little bit more. But rather than just shutting someone down and saying, no, we don't do that, make sure you're really understanding what it is they're asking for. Are there any alternatives that you can suggest, which don't have to be accepted by the person with disability? They're presumed to be in the best position to know what they need, but they can be suggested. Okay, so to try and demystify this, HUD issued a 19-page guidance in January of 2020. So they attempted through a multiple step analysis to try and make this really clear. Again, I'm going to refer you back to those 3 steps: disability, nexus between the disability and what's being requested, and is it reasonable? So if in doubt, just go back to that as the starting point. But this was new guidance that was issued by HUD in 2020. It replaced some prior 2013 guidance, and I don't think it significantly changed very much. It did add a couple of clarification nuggets that I'll point out as we go along this morning. But they get so many questions. This is the most common, disability is the most common basis for fair housing complaints in the country now. It's the most common basis in our region. And then of disability-based complaints, reasonable accommodations are right up there, and assistance animals are most of the accommodation complaints. So there's need for this clarification. As a handout today, I provided a PDF to Liz, which I believe will be made available to you, that is the 19-page guidance from HUD, as well as an article that I had prepared last year that's about 6 pages, attempting to synthesize some of this down a little bit more. So hopefully you'll have those as some resources for later. There was an issue as to whether or not this guidance was still in effect, even though it was just issued last year in January 2020, because apparently the GAO, the Government Accountability Office, found that HUD had not followed all the particular procedures to notify Congress of this rule. And so subsequently, after the decision from GAO, then HUD went ahead and followed the proper procedures. So I've been advised by HUD that this is in fact in effect, but there was a minute where it was not in effect and we were back to 2013. But this is going to be your go-to guidance from here on out until HUD issues something else. Okay, so this guidance doesn't address any other additional requirements imposed by Section 504 for federal funding or the ADA. Areas of housing that might be covered also by the ADA are offices, rental offices, your broker's office, if it's a multi-family housing complex, perhaps the rec room or swimming pool areas, anything that might be available to the public for rental or use. So this guidance doesn't address those laws, so keep in mind there may be some additional requirements imposed on you depending on the type of housing you're working in. This guidance also does not cover airlines and common carriers. We often see in the news the turkey that gets on the airplane, or the peacock, or some unique animal, and it makes a big fuss on the airline, and there's disputes, and some of the airlines now are revising their rules about what's permitted. When it comes to housing, we ignore all that. Okay, so that does not pertain to housing at all. So don't be swayed one way or another by what you see in the news about airlines. So this guidance is focusing on housing only. It's also supposed to be read in conjunction with HUD's other regulations and the 2004 joint guidance from HUD and Department of Justice on reasonable accommodations. So that is not specific to animals, but it is a good overview of reasonable accommodations in a Q&A format. It's from 2004 and it's still effective. So if you're just trying to make your way through a reasonable accommodation analysis, that's a good place, a good resource to start. And so since assistance animals are a reasonable accommodation, HUD says to read this 2020 guidance in conjunction with that joint guidance from HUD and DOJ. Okay, the guidance is prospective, so housing providers don't need to go back in time and reassess any reasonable accommodations that they've already granted for assistance animals. It's prospective, it goes forward. So you don't need to dig out any files you have and try and determine if the person should have the animal or not under this new guidance. And the guidance is divided into two sections. The first part, which is the meat of it, it's most of the memo, is assessing a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. So this is guidance that is supposed to help housing providers understand whether or not they should grant the accommodation request. It's divided into 5 parts. And then there are a couple pages at the end, which is intended as guidance for somebody who is trying to provide documentation that they need an animal. So that's something that housing providers can give to people if they are trying to figure out what they need to show that verifies they need an animal. Okay, so we're gonna walk through this. At the beginning of the guidance memo, there's some discussion about what is an assistance animal. Assistance animal is a term that HUD started using a few years ago as an overarching term to encompass service animals, emotional support animals, companion animals, basically any animal that's needed for a disability. Service animal is a term of art under the ADA. It's very restricted to the dogs, the miniature horses that are trained to perform a task, to do something for a disability, for someone's disability. That doesn't include emotional support animals. But assistance animals under the Fair Housing Act include all kinds. So HUD does then further break this down to the service animals, the ADA animal, and then other animals that may be emotional support type animals. Okay, so this is the first part, assessing whether or not you need to allow an animal in a housing situation. So basically the first part is just to determine, does it meet the definition of the ADA, the service animal? Because if it does, those animals can go everywhere. Just like they can go into the grocery store, they can go to the library, they can go into your housing with you. So if you figure out that it's a service animal, then you're done. You don't need to go further with the analysis. But the first part 1, is the animal an ADA service animal? Well, is it a dog that's individually trained to do work or perform tasks for the benefit of somebody with a disability? And disabilities for the Fair Housing Act and the ADA include physical and mental disabilities. So it can basically be any type of a disability. So is it a dog that's individually trained? Or miniature horses. It's just the miniature horses are in a different section of the regulations. If you're dealing with a miniature horse, you might also be in the ADA area. But other species, again, the parrots, the mice, gerbils are not service animals under the ADA. So if you've got a dog that's trained, you go on to question 2. If it's not a dog, then it's not a service animal. And so it might be some other kind of animal that qualifies as an assistance animal, and you still need to give a reasonable accommodation under the Fair Housing Act. You proceed to part 2. But if you're dealing with a dog, then you go into, is the dog trained? Is it trained to do something for someone with a disability? Is it obvious that it's trained? And an obviously trained dog is one probably being used as your seeing eye dog, or to help somebody who cannot hear, you know, if it's wearing a harness and the person is obviously has a physical disability, a sensory disability, and the dog is helping, then you can take that at face value that the animal is trained doing something to help the person. But not all disabilities are obvious. Not all uses of animals are obvious for disability assistance. So if it's a dog and it's obviously trained, you stop there, you grant the accommodation, it's a service animal. This is just like going to the movies or something. But if you're not with a dog and it's not trained, you continue on. So the next step, it's a dog, but it wasn't obviously trained. Then you get to ask, is the animal required because of a disability? You get to ask two questions. Is it required for a disability? Okay, if somebody says yes, it is, then if the work and training wasn't obvious, you get to ask what kind of work is it trained to do? What's the animal trained to perform? And the person, if they identify one action that the dog is trained to do, other than emotional support, again, you're at, this is an ADA animal, so you allow it. So to simplify all this, is it a dog? Is it obviously trained to help with a disability? Allow it. If it's not obvious, you get to ask, is it needed for a disability? What is it trained to do? And then if they provide one action that it's trained to do for a disability, that should be sufficient, okay, unless it's emotional support. So at that point, you're done. However, if you're dealing with other types of animals or animals that are not specifically trained to perform a task or do work for a disability, you continue on. So if the answer is no, it's not required for a disability, and the answer is none, it doesn't do any work or provide a task, now you go on to part two. So part one is just all of, is it an ADA animal? Okay, part two, okay, is it a reasonable, does it need to be allowed as a reasonable accommodation under the Fair Housing Act for animals other than assistance animals? So you get to ask the next questions. Okay, has the person asked for a reasonable accommodation to keep an animal for a disability? And a request can be in writing, it can be verbal. It doesn't have to be in writing. It's preferred that it is, so that we all know what the starting point is for the discussion, but it could be verbal. It doesn't need to use the phrase, I need a reasonable accommodation, so long as somebody is making clear, I have a disability, I need an exception to a rule for my disability. Okay, sounds like you're asking for a reasonable accommodation. It can be requested at any time. Now, this is one of those little nuggets I said that did drop into this lengthy memo, because there's a lot of confusion and resentment when somebody who's already in a housing situation suddenly shows up with an animal and then makes the request, or they get a notice that says you're not supposed to have pets in this housing association community. And we see you have a dog there, so you get a notice of some type and a violation. And so that can look like somebody's been sneaky and not being forthright about having an animal. However, in our experience working with people with disabilities, oftentimes people don't think about asking permission from their housing community or housing provider to have an animal. If their doctor tells them to go get one, they do what the doctor says. If the doctor says, you need a shower chair, you could benefit from that, they go get a shower chair. They don't think they need to check in with anybody. If the doctor says you could use an assistance animal, to help you with your depression, they go get the animal, and then all of a sudden now their housing community or provider or neighbors are wondering what's going on here, why do you have this animal? So it's not always from trying to be dishonest, but sometimes the timing doesn't really go in sync the way we would like it to, in a chronological order from moving in. Also, people's disability needs change through time. So they may move into housing not needing an animal, and then their disability changes and their healthcare provider then prescribes one. And so it doesn't always pop up at the beginning. But HUD does clarify that it can be requested at any time. and the housing provider needs to consider that request, even if they've already brought the animal into the housing and there's a no animal policy and it appears they violated it. The housing provider needs to consider that request. So that was a nice point of clarification, because that situation comes up a lot. Okay, so also, has the person requested a reasonable accommodation? In that section, HUD clarified a couple other things. There's often, people wonder, can you have more than one animal? Can there be more than one animal for the same disability? Do you need different animals for different symptoms? And so HUD provided a little bit of clarification in saying that so there can be more than one animal involved in a reasonable accommodation. So you may have a person who has disability related need for 2 animals. You may have multiple people in the household and each one has an animal. That happens too. People who seek our assistance, sometimes there's a parent and then a child and they have different disabilities and different needs for animals. So basically, it does clarify there can be multiple animals. You're going to do the same analysis though on each animal, because it may be that some are pets not needed for disabilities, and then they could be prohibited or pet fees charged or whatever the housing community rules are. Or if they are needed for disabilities, they need to be allowed probably. Okay, so persons made a request for an accommodation, an exception to a rule to have an animal for a disability. You proceed to part 3. Okay, so part 3 is now they've made the request. How does the housing provider know when to grant it? When should they allow the animal? So remember the 3 steps. Do they have a disability? Okay. Is there a nexus and is it reasonable? So we're at, do they have a disability? Is it observable? Is it obvious? Or does the housing provider have some information already in their file indicating the person has a disability? Maybe they've shown they have SSI income or SSDI income. And that's, you need to have a disability to qualify for those types of incomes. So that would be sufficient to show that the person does have a disability. So is it obvious? And disabilities can be physical, they can be mental. To qualify as a disability under the Fair Housing Act, it needs to substantially limit one or more major life activities. And life activities are things like working, lifting, walking, breathing, things that most of us that don't have disabilities take for granted. Some impairments are obvious, and HUD gives a list of things here that are probably obvious disabilities: blindness, deafness, epilepsy, and so on. However, there are lots of disabilities with impairments that are not observable, that are not obvious. And in that case, the housing provider can ask for verification of the disability and disability related need for the animal. So again, is it obvious or not? It's sort of like the ADA analysis. If somebody's using a dog, is it obvious that they're using it to do some work for them, to help them? Okay, so these are things that HUD says will in virtually all cases be a disability, but it's non-exclusive. Other conditions can also be disabilities. So again, it can be mental or it can be physical. This is a point of difference with our state law. The Washington Law Against Discrimination recognizes temporary or mitigated disabilities. So disabilities that are mitigated perhaps through medical devices, surgeries, medication. Our federal law, court cases have kind of winnowed down some of our things that qualify as disabilities if they can be mitigated. Our Washington law doesn't is much broader in that area. Our legislature several years ago went back and forth with the state Supreme Court, and the legislature finally came out and said, we mean temporary mitigated. So somebody could be on bed rest for a high-risk pregnancy for several months, expected to recover, and that could be a temporary disability. Somebody with a broken hip might have a temporary disability. It's expected that they're going to be healed and walking at some point, but during that time with the broken hip, they would probably qualify as having a temporary disability under our state law. So that's one area where our state law is more broad. Okay, so if the disability is unknown, you get to ask some verification questions. If it's known, you go on to the next question. So obvious disability, somebody using a red and white striped cane, a wheelchair, a walker, those are probably disabilities that are obvious. But if you don't see the disability, which is quite common, then you get to ask some more questions. Okay, so verification of disability. Have they provided information that verifies they have a disability? If not, the housing provider can ask for that. The housing provider cannot ask for the nature and severity of the disability. So shouldn't ask, do you have, you know, a specific condition? Do you have HIV? Do you have epilepsy? What medications do you take? Or have you been institutionalized? All those questions are off the table. They just need to know that A, there's a disability and a disability related need, but not anything about the nature or severity of the disability. So information that somebody can provide as verification they have a disability includes, again, SSDI, SSI, Medicare, things that people, types of benefit documentation that's received for people with disabilities, and typically a letter from a third-party verifier, like a healthcare professional. And these are some of the examples that HUD gives: a physician, an optometrist, a psychiatrist, psychologist, so on. The 2004 Joint Reasonable Accommodation Guidance includes a list of who can provide verification for a reasonable accommodation. It's pretty broad. It basically gives examples of, you know, doctors, nurses, social workers, peer support group people, and also concludes anybody in a position to know. So basically anybody or any reliable person in a position to know. So sometimes your family member is going to know the most about your disability, so they might be in a good position to know. Are they going to be considered reliable in a fair housing complaint? Probably not. They're probably going to be looked at more as a biased witness. But the 2004 guidance is really pretty broad. It doesn't have to be a doctor in who verifies. Notably, in this assistance animal guidance, HUD seems to be tightening up a little bit. Again, it's not exclusive. It can be other things, but the types of people that they're listing here seem to be more like medical doctors and practitioners. So, okay, so the person provides information. Verifying disability if requested by the housing provider, if the disability is not obvious. These are some other good nuggets that came out of this guidance, because there was a move for some housing providers to require specific forms be completed by healthcare providers or for the person asking for the accommodation. They were asking healthcare providers to provide notarized statements or sign under penalty of perjury that this person needs this animal, or they'd be, you know, thrown into prison if they were lying. And so that obviously has a chilling effect on some people making certain prescriptions for their patients. So HUD said that the housing provider can't ask a healthcare professional to use a specific form, a notarized statement, sign under penalty of perjury, or provide really detailed information about the disability, the diagnosis. Sometimes doctors don't know that though, and you will commonly see letters from doctors that share way more than they should about medications, symptoms, and so on. So there's need for education in that area too. Okay, and then the guidance also talks a little bit about internet verifications, which might be on some of your minds. With technology, our laws don't always keep up with the evolution of things that we can do online. And so essentially this guidance acknowledges that there are legitimate reasons for having internet verifications, and then there are certainly misuses of it. And so there's an acknowledgement that there are websites that sell a certificate or a registration for a fee for the person with the animal to get their animal on a registry and get a certificate that says, I have a registered service animal. And HUD says that by itself is not enough to establish either a disability or disability related need. I would add, focus on the person, not the animal, because it doesn't matter what certificates, awards, credentials the animal has. We don't care about any of that. There's no requirement that the animal have gone to a specific school, have graduated. There's no national registry that's required for ADA or Fair Housing Act animals. And so some of these are scams, you know, where they're taking money really from people that are on fixed limited disability income oftentimes, and they think they're getting what they need to be able to have their animal. But If the certification talks only about the animal, you know, FHEO is a certified animal on this registry, that's not going to verify disability because it doesn't say anything about the person, and it's not going to verify the need, the nexus that the person needs an animal. It just talks about the animal, and that's nice to put on your shelf if you want, but that's not going to suffice for verifying need for the animal. Conversely, though, HUD's guidance memo says that there can be reliable documentation if it confirms the disability and need for the animal when the provider has personal knowledge of the individual. So there, especially in these times of COVID-19, people can see healthcare providers virtually, and you know, you can consult with your healthcare professional, send them photos of medical conditions, and they can prescribe based on that. So, and this can be a big help as well for people who are homebound because of disabilities or live in rural areas where they can't get to medical care as easily. So there are some great benefits and legitimate reasons for having an internet relationship with a healthcare provider, but the documentation really should focus on the person. I'm treating this person, I'm their care provider, you know, this person has a disability, this person needs. So rather than focusing on what the animal is, the letter should focus on the person and their needs to indicate that this person is putting their credentials, but you may still doubt it, and there still may be some scam aspect going on. But if the person is willing to put their credentials on the line, sign off, say this person has a disability and needs the animal, probably at that point from a risk cost benefit analysis, you probably don't want to get into denying that type of an animal verification and then end up in court, and then you have to have dueling experts, and did this person, were they really qualified to say this person needed the animal or not? I just, once you've got the verification, I would accept it at that point if it talks about the person's disability and their need for the animal. So a little bit of guidance there, not a lot, but we got a few glimmers from HUD there on how to treat the evolving technology. And then continuing on with whether to grant the requested accommodation. Okay, if the person has provided information that they have a disability, you go on to the next question. This is the nexus. Again, remembering the three things. Do they have a disability? They provided verification if it's not obvious. Now we're into nexus. Is there a connection between what they need, what they're asking for, and something they need for their disability? So the animal needs to do something, provide work, provide a task like the ADA animal, or in the case of a comfort animal or therapeutic emotional support animal, which is allowed in housing, not in public spaces, they need to offer some kind of verification that it's needed for their emotional support. So again, the letter can come from here, a psychologist, a nurse practitioner, a physician's assistant. They give some examples. So you're looking for verification of the disability and need for the animal if those are not obvious through seeing the person's disability and their use of an animal. If the person has not provided documentation, then that verifies disability and need, then that could be grounds for denying the reasonable accommodation. If they've provided the necessary verification, then you can go on to part 4. Okay, this gets into the type of animal. So again, there's no regulations under the Fair Housing Act about animals or types of animals, unlike the ADA, which is dogs and miniature horses. But HUD does start to make some distinctions between, in this guidance, is it a commonly kept household animal, or is it a unique animal, something different? So if it's a dog, cat, little bird, rabbit, gerbil, fish, turtle, those kinds of things, traditionally kept in home for pleasure rather than commercial purposes, and the person's provided their verification of disability and need for it, then it should be granted. You stop right there. There are unique animals, however. Reptiles, monkeys, kangaroos, other domesticated animals that are not household animals. And so with respect to these unique animals, I think a lot of people from this guidance took away that means a housing provider doesn't need to allow them, but that's not quite the case, because HUD does say that these unique animals may need to be allowed if there are unique circumstances. So unique animals that are justified by unique circumstances. So it's something maybe that can't be performed by a dog. Maybe a person has allergies to a dog, but they need some other kind of animal that doesn't have allergies or doesn't stir up their allergies. Basically, this is, I think, the catch-all though. If without the animal, the symptoms or effects of the person's disability will significantly be increased, then it may need to be allowed. So that's really a catch-all, because if somebody has a unique animal and they're bonded to it, and their psychological disability is going to, have adverse symptoms increase if they're denied the animal, I think that, they may be able to provide verification that they need that specific animal. Now, there are certainly local ordinances and laws and things like that. And I think a housing provider is okay to say, I'm sorry, you're not allowed to have a poisonous snake here because our ordinance says no poisonous snakes. If you want to take it up with the city or the county, go ahead and ask them for a reasonable accommodation, and we'll see where we go from there. But or a cow or something, a large cow, if that's not allowed in your jurisdiction, then the housing provider can say, we can't violate the law here. The law says no cows or large horses in our city limits. Then that's grounds for denying the unique animal, but at least needs to be considered no matter what kind of animal it is. Another example that they give in this guidance memo is the individual keeps the animal outdoors at a house with a fenced yard where it can be appropriately maintained. So that really gets into the type of house it is. One interesting scenario that's coming to mind here in Spokane, some of you probably know this much better than I do, but I know we have limits on, how many dogs, how many cats you can have, how many chickens, that's kind of a new thing, raising city chickens, urban farming. And there was a household that someone on our staff was working with, and there were two houses neighboring each other in the city, and one had a variety of animals. And one family had a son who had some disabilities. He had autism, I believe. And the family with all the animals got in trouble with the city and were told to get rid of some or all of their animals. Well, what had happened is the son with the disabilities had become very attached to, I think it was a little goat that was next door. And so working with all these people involved, working with city officials, there was a reasonable accommodation that was granted for this boy to be able to keep that one little goat. I don't know if they actually then moved it over to his house, but that was something that, you're dealing with a unique animal, but it became part of his routine, going over and feeding it every day, whatever, and they determined it was helpful for his disabilities, and so he was allowed to have it. So sometimes you need to reach above the immediate homeowners to the city officials sometimes to get an accommodation as well. So anyway, unique animals, so it's still possible to have accommodations for them, but HUD does put in a little bit more cautionary language there of analysis. And then general considerations are included in Part 5. The housing provider can only refuse the reasonable accommodation if the specific animal poses a direct threat. So a lot of times we think about a pit bull or some dangerous breed dog. If that specific animal has a history of biting, being aggressive, and that's known, then the housing provider could deny that as an accommodation if the aggression can't be eliminated or reduced through some other acceptable means. So, maybe it's, having a muzzle on the animal or something that was barking or acting aggressively or something. Sometimes you just can't reduce the risk though. But it has to be that specific animal. It can't be an assumption, a generalization, a stereotype about that breed. Some of you might ask, what about homeowners insurance that sometimes has dangerous breed lists? Well, remember, insurance is covered by Fair Housing Act as well. So rentals, sales, appraisals, insurance, all those transactions relating to housing are covered by the Fair Housing Act. And there is a memo, goes back to about 2006 from Brian Green when he was with HUD. Some of you now may know him with with the National Association of Realtors. He recently joined their team from HUD, but there's a Brian Green memo from about 2006, and it talks about insurance, that if there is legitimately a dangerous breed insurance prohibition on the animal, then the housing provider is okay to deny that as an accommodation because they lose insurance. But they can't just say that. They have to actually consult the market, talk to their insurance broker. Could they get comparable insurance for the same price, or would it go up dramatically? Is this really in the policy, or is this just something they think is in the policy? So once they've done some due diligence and said, yes, I'm going to lose insurance, it's going to cost me a lot to get more to cover this situation, then they can say that's an undue financial burden. I'm not going to grant this reasonable accommodation. But the memo concludes that insurance companies that don't grant reasonable accommodations will be referred to Department of Justice for enforcement. So if you're dealing with that situation with insurance and a specific breed for an assistance animal for a disability, there is a memo that you could send over to the insurance company, say, hey, we need to all make an accommodation in this situation, unless that specific animal is known to be a direct threat. So a little bit of information there. Best practice, housing providers should grant, make a decision on the request for an accommodation within 10 days. So that's something new. It's best practice. It's not a mandate. There's a discussion of good faith dialogue, interactive process, having that. Again, I mentioned already the interactive process, so I'm just, for sake of time, going to move through. An assistance animal is not a pet, so there shouldn't be a fee imposed for asking for the request, a deposit, a surcharge for having the animal, specific pet insurance for the animal. All those things can be imposed for pets, but not for an animal needed for a disability. Think of it as like an auxiliary device, like a wheelchair or a cane. You can't put a charge on that. You can charge, housing providers can charge if the animal actually damages the property, but you can't assume it's going to. Can't limit the breed, size of the dog or animal. It's a reasonable accommodation. So communities can have all kinds of rules, no cats, no dogs, no animals over 30 pounds. Reasonable accommodation is asking for an exception to that rule. So it could end up being a bigger dog or a bigger cat than would otherwise be allowed. And then the person with the animal needs to ensure that it's cared for, that it's under their control, it's not running around the premises, it's not barking at all hours of the night, or they're going to receive violation notices. This last portion just gives some guidance. This is the second portion of the memo. I'm starting to go a little faster because I want to make sure that we've got about 10 minutes at least for questions. So that gives me about 2 minutes to wrap up here. This last couple of pages of the guidance is supposed to help people with disabilities know how to talk to their health care providers to get appropriate documentation and verification. So again, all of this is best practice, best guidance, but if this is what HUD is saying is sufficient, it probably behooves somebody who's working with somebody to get a reasonable accommodation verification to try and follow this format. Signature on it, the patient's name, specifying they have a relationship, you know, this is my patient, I've treated them or whatever, that they have a disability, physical or mental impairment. And then if it's for an animal, discussing either the animal does work or provides assistance for the disability or provides therapeutic emotional support, saying something along those lines. That's the need, the nexus. And then a description of the animal is helpful if it's, especially if it's a unique animal, explaining what that animal is. Any unique circumstances justifying this particular animal is needed. Lastly, the Washington Law Against Discrimination. Again, we had so much confusion with the ADA, the Air Carrier Acts, the Fair Housing Act. Our Washington law was quite confusing to the situation for a while as well, because the Washington Law Against Discrimination until very recently, until January 2019, included a definition of service animal applicable to housing situations, very much like the ADA. It was this really strict trained to do work or perform a task definition. And so housing providers that only read the Washington law or consulted attorneys who only knew Washington law, but didn't know the Federal Fair Housing Act said, oh, you're fine to deny an emotional support animal that's not trained to do anything. That's just, inherently comforting to you, but it's not trained, so you don't need to allow it. It's a cat, it's not a dog or a miniature horse, don't need to allow it. So that really set housing providers up, I think, for failure if they didn't know and no one was telling them that there's also this Federal Fair Housing Act that says, no, in housing, it can be any kind of animal. So finally, after the Washington State Human Rights Commission going to the legislature several times over the years, this was finally fixed. And effective 2019, there's no definition for housing for the assistance animal. You just go through this reasonable accommodation analysis we've been talking about this morning. In employment and places of public accommodation, however, that service animal definition applies, being trained, dog or miniature horse, just like the ADA. So it all comes down to the realm and where you're working, but finally we have our state law in sync with our federal law. So hopefully as time goes on, that will start to dispel the idea that some housing providers have that they don't have to grant accommodations for emotional support type animals. And this is just the specific language. They added this last sentence in blue because you start out with a definition of service animal, means dog, miniature horse, and then it says the subsection does not apply to the sections regarding real estate transactions. So they took it out of the housing purview. So got us aligned there. So 19 pages of HUD guidance. There's an article of about 6 pages. I tried to synthesize it down to that I think will be made available to you. But if you remember nothing else, an assistance animal is a reasonable accommodation. Person needs to have a disability, needs to have a connection between the animal they're asking for and their disability, and it needs to be reasonable. So the animal hasn't been known to bite and attack other people. It's not a giraffe in a city that doesn't allow giraffes, that kind of thing. So. Okay, well, I will open it up to any questions that might have come in or that people have at this time.
Fantastic, Marley. Thank you so much. And there's been a lot of chatter going on in the box there. And so Liz, who is staff with Washington Realtors, is going to help us kind of sort through some of that. But again, it's a tremendous amount of information. Just staying online with the theme of animals, this is an old dog that just learned some new tricks. And so thank you so much. Liz, please help out.
Questions, but during your presentation, you answered a lot of the questions that were in chat, and your coworker Shannon helped as well. So that's greatly appreciated. We appreciate that. But we do have a couple here. What protection is there available for those that abuse the system? And will HUD ever address the issue of fraud?
Okay, interesting. I don't know about HUD. I know that states have taken to passing laws, including Washington. The same time they added that amending language to the service animal definition, they passed a law in Washington that makes it I think it's a misdemeanor, but it is a crime to fraudulently represent that you have an assistance animal for a disability when you actually don't. So it is a crime. Proving it and that kind of thing is always based on the facts. But some of the states have taken to doing that. I would say, there are always going to be people who get over on the system, but just try and keep focus on there are some people that really need these things, and that's why we have these laws. Once somebody's provided the appropriate documentation, then really it's just a compliance issue after that. Depending on the housing provider, they can give notices if the animal's violating rules in the community, being not the animal, the owner of the animal, the animal's being noisy, noise violations, nuisances, things like that. So you obviously don't want to single out that person because you suspect they don't really need it, target them. But if they're making noise, if there's issues, then address that as they come up. But maybe there won't be any issues, and maybe somebody got away with something. But just focus on that some people do really need these animals. That's, I think, helpful.
Along those lines, Liz, let me interrupt for a second because I saw one of the questions. Along those lines, someone was asking, what happens if the person doesn't use a pooper scooper, but they don't seem to have the inability to do it themselves? They're just being lazy. Is there a way to have them responsible or charge them for the cleanup service?
Yeah, you can ask that the person be responsible for the cleanup of the animal. Now, that might be themselves, it might be a caregiver, a family member, a household member. It might have to be not that very second it happens if they're not mobility able to do it, but to, get someone in the household to do it. But yeah, you can ask for the animal to be cleaned up afterwards. It's good design is goodwill. I think Shannon will tell you that. She's from our office and been answering some of these questions. If you don't have an area, if it's particularly a big housing community and there's no area for the animal to go, you're going to have problems. So it's best to like make an area, a gravel area, that's the designated area. That will help a lot, rather than having no area and then being concerned that the animal is damaging the grass here or there, going in all the wrong places. So it's kind of like the smoking area, right? Have the house out there, because people are going to go out and smoke no matter what. So give them a place to do it to try and help some of the problems. So.
Can the age of the dog be limited? Must be 1 year old, for example?
I've not seen anything from HUD to indicate that. I'm sure, yeah, issues of potty training probably come to mind. The person's going to be responsible for any damage. If it's not their own house, if they're in, rental housing, they're going to be responsible for any damage that does occur. So hopefully they're trying to use potty pads and things like that. But there's nothing as far as age that I've seen as far as restrictions that can be placed.
Okay. And there's a couple questions about allergies. How do you deal with a home buyer who has a service animal, but the seller is allergic to the animal and requested that no animals enter her home for showing? Same with, renters. If one renter is allergic to the type of pet, can they be denied for that reason?
Yeah, interesting question. So it really, I think, is going to come to how does the person with the allergy rise to the level of having a disability. Some allergies are annoying and inconvenient. Other ones are, substantially isn't a substantial impairment to major life activities, breathing or something. And so if you're dealing with somebody who has verified they have a disability, then I think you need to try and accommodate them as well. When it comes to dueling tenant or neighbor situations, I think if the first person has gone on record, that's most helpful. So it doesn't look like after the fact they're saying, well, no, I really have this allergy disability. If they've said, I moved in here, I have this really, severe disability, it's going to be life-threatening. If somebody with a cat moves in next door, could you please not rent to somebody with a cat? They've put their request on record, and maybe the manager can deal with that. For a seller, the same thing. Does the person's disability, is it inconvenience, or is it really, a legitimate disability? And you just need to try and be creative too, I think, in is it possible, if the person is really serious about this house, maybe first, can you do some virtual pictures without them coming in with their service dog? Can you do a video tour? And then if they're really, interested in this house, they probably need to go in and be able to see it. But can we have the windows down and arrange for the seller not to be there, or whatever? You just have to sometimes communicate and try and come up with solutions is my best suggestion there.
Okay. And then we have time for one more question and then we'll end. Did you say if there can be a limit on how many comfort pets one person can have in their name? I've received letters stating all their pets are needed for different anxiety. Yes.
There's no limits. I would look to, however, if you have a state or city ordinance, for example, based on square footage, where I live, based on my square footage, I can have, I think it's 2 cats and 2 dogs, up to 4 kind of these domestic animals. If somebody has 5 or 6, that's going to be violating probably the local ordinance. Then I would refer them to talk to the city to see if they can get exception or not. If they can't, they can't. The more animals you have, however, the more smells, the more noise. So then you're not so much into the permission of allowing them to have them, but once they're there, okay, now you're into compliance area, probably, if they're barking at all times or not cleaning up after the animals or whatever. So you just have to take them one by one. Are they all needed? And if they are, is it violating any local ordinance or county ordinance that you can say, no, I'm sorry, you're not allowed to have them under that basis.
Okay.
I have a question. Do you hear me?
Yes.
What about if a tenant applies and the landlord lives in the house? So basically, it's a roommate situation. Are there any differences or limitations? Let's say I live in the house and I'm looking for a roommate.
Yeah. Yeah, roommate situations, the Fair Housing Act essentially stops at the door. There's a Ninth Circuit court case about that. So if you are sharing, kitchen, bathroom space, you're essentially having a roommate in your own home. You can limit people based on, animals, based on religion, if you only want to cook kosher or whatever, your preferences are. So yes, when you're sharing space, the Fair Housing Act essentially stops at the door.
Right. So, but some houses and have ADUs that have like separate kitchens, separate bathrooms, but central heating system, for example. Is it also the same? Because it's not a duplex. That some homes have like ADUs that share heating system, or they don't share kitchens or bathrooms.
Yeah, I see what you're saying. So they have their own space. So normally the person should be able to have their animal in their own separate space. If you're dealing with a small landlord that's not using a housing professional, if you're not using a real estate broker and you're just selling or renting your own home and you only own a couple, then there are some exemptions. And so I didn't really have time to go into those, but there are some exemptions. If you own 4 or fewer single family houses, you do all your own rental or sales business yourself, then you're exempt. Or if you live in a building that's divided into 4 or fewer separate units, so maybe an old Victorian divided into 4 different units, the owner lives on site in one of those, then they're exempted from having to give reasonable accommodations for disability.
I see.
Yeah.
Thank you.
You're welcome.
Okay. So let's hold any other questions. If you do like to pursue a little bit further, please feel free to send your questions directly then to Liz, and we'll make sure that we can get an answer for you. But we want to be able to try and end as quickly or on as much time as we possibly can. So in wrap up, again, on behalf of Washington Realtors, Marley, thank you so much for the great presentation. And we'd like to thank all of you for attending today's session. We know that next week, many of you are going to be at the spring conference via Zoom for Washington Realtors. So there aren't going to be any classes, but there are 2 additional sessions that'll be coming up. So please join us on April the 27th. You want to mark your calendars for a presentation with HUD that's going to be dealing with realtor case issues. And then a couple of days later, on April the 29th, there's going to be a presentation on implicit bias. Implicit bias. This seems to be a great buzzword nowadays, but so apropos for the times that we now live in. And so with that, everyone, thank you so much. We want to thank Marley once again, and Shannon, her able-bodied assistant, who I thought she was a realtor that had all this great knowledge. I'm saying, wow, Shannon's remarkable. And to come to find out, she knows as much as anybody, if not more than most. But again, it was just wonderful. And Liz, thank you, and Washington Realtors for bringing this to our attention. Everyone, have a wonderful day, and please stay safe out there. We look forward to the opportunity we'll be able to see each other in person. Thanks again. Enjoy the day.
Thanks for having us.
Marley. Thank you, Jerry. Take care, everybody.